All right, let's see. All right, something was wrong with my intro there. It was kind of gobbledygook jumping there. Just wanted to do some breaking news. How are you doing, Tim and Joe and everyone else out there? We do have some breaking news. So, of course, since we have breaking news, I have to run a couple different things here just to see if everything is cleared out. Yeah, I have no idea what's going on with the video, but whatever.
Breaking news! Breaking news!
All right, so this case is a case out of California. Volume is a little light. Is that better? Let me know. This case is out of California, and it is known as Nguyen versus Bonta. Bonta, of course, is the AG of California. Nguyen is the plaintiff, the named plaintiff. There are several plaintiffs in the case. I'm going to link the document down below just so you guys can read it yourself if you want. But this is Michelle Nguyen, who actually filed it with a couple other individuals, along with the North County Shooting Center, Fires Policy Coalition, San Diego Gun Owners, and the Second Amendment Foundation. They all teamed up to file this case, and it is challenging Nguyen. All right, sorry. And it is challenging the California one gun a month, or 1 in 30 law. The 1 gun a month law affects all handguns, and also it affects semi-automatic rifles. Basically, they're saying that you can only buy 1 handgun or 1 semi-automatic rifle in a 30-day period. There's a lot of states that have these around the country. Some states like Virginia does have this, but we have an exception. If you have a concealed carry permit, it doesn't restrict you. Other states, it does restrict you even if you do have a concealed carry permit. So this case will have an impact across the country. If FPC, Second Amendment Foundation, San Diego Gun Owners are the organizations that helped bring this case. And it might help the law in Virginia. It was at the district level, and this is a summary judgment, which is more powerful than a temporary injunction or a permanent injunction. It is summary judgment. It is done with the district court level. And the defendants, which is California, tried to get the summary judgment, and so did the plaintiffs. The judge in this case, his name is what is his name? Damn it. Sorry. William Hayes. William Hayes is the judge. He is a judge in the Southern District of California, and he granted summary judgment for the plaintiffs. There is a stay on the judgment to give the state time to appeal, and there is nothing entered in right now. I mean, the summary judgment's entered, but the law is still in effect for at least 7 days. They have 7 days for to file what's called a proposed motion for judgment, which is a motion saying this is what we think the outcome of your decision should be. We do know the law is knocked down, but even after those get submitted to the judge and this judge decides, there is still a 30-day stay on his own decision. He did a 30-day stay on his own decision to give the state enough time to appeal to the Ninth Circuit Court of Appeals. So will this law actually, even though it's been knocked out, actually go out of enforcement? I don't know. It depends on the Ninth Circuit Court of Appeals, but we all know where the Ninth Circuit lands on that. What I suspect is the Ninth Circuit is going to stay the judge's decision until they have a chance to review it, whether that be by a 3-judge panel, which it should be, or if they just say, hey, we're going to grant en banc to this, which they have done, even though it's not common. They've done that in the past, but it's probably going to go to a 3-judge panel in front of the ninth, because I'm pretty sure that they are going to actually stay the judge's decision. So let's go ahead. I'm going to bring up the case file so you can actually see it, and we'll go from there. This is the judge's opinion right here. Hey, go ahead and share this. It would help, right? I'm going to blow this up a little bit so we can see it. I'm not going to read through all of it, but I am just going to give you guys the highlights of what is going on here. Basically, the plaintiffs are arguing that the 1 in 30 violates the Constitution because, for example, you can buy more than one Bible in 30 days. You can buy more than one book in 30 days. So they are putting a hard limit on exercising a right, which is not good at all, because you shouldn't be able to limit rights that way. So all these gun organizations got together and they filed a complaint, and this was them. They filed for a motion for summary judgment. The defendants also filed for a motion for summary judgment. So it was like a cross motion filing there. California, what they really hung their hat on was gunpowder laws from the 1790s and afterwards, but the judge didn't buy that. The judge basically threw that out, saying that it's not effective. He cited Bruin in here, he cited McDonald, and he cited Heller, the holy trinity of gun cases. And every pro-gun case will cite those 3 cases. That's why they're known as the Holy Trinity. And there is another case, Ezel, which is up there with these cases, but this was cited with the Holy Trinity. And basically, the judge said that you have the right to acquire as many firearms as you want in a shorter time as you want, because that's the Second Amendment. You cannot limit the frequency of exercising a right. That's just not the way it is. And I 100% agree with that. But California, they did a historical they analyzed the laws historically, and yeah, it is definitely interesting, because they went from everywhere from like early gunpowder laws, like 1783, all the way up to 1909. If you know, laws that are analogs are closer to the founding period, which was 1791. So the 1901, sorry. The 1901 laws, I'm not sure why they even cited those, because that's way after the founding era, and you really can't consider 1901 the founding era. And gunpowder laws were a little bit different than that. California tried to argue that this law was necessary to prevent gun trafficking, which is also ridiculous, because I've been known to buy multiple guns in a single day, much less one gun in 30 days. So, yeah. And they also tried to do deadly weapons from like 1881, which is really funny. These consist of brass knuckles, also Bowie knives, and some other types of weapons, not even firearms. What is it? Brass knuckles, Bowie knives, and there was one other. Shit, I don't know. Brass knuckles, Bowie knives, and others. Then they did taxing and licensing regulations from 1763 and 1790, which deals with a license to trade in firearms, which has nothing to do with 1 in 30 days. Blackjacks, that's it. Thank you. So that is kind of funny that they try to cite other laws that have nothing to do. Yeah, billy clubs. Yes, I agree. And they all should be legal, but they were trying to cite those as an analog to a one gun in 30 days. So basically, they were throwing a bunch of crap at the wall and seeing what stuck. So they dealt with taxing of firearms, licensing of dealers, and banning of brass knuckles, Bowie knives, blackjacks, and other things, which the judge basically said, you're full of shit. This has nothing to do with anything. It has nothing to do with the case. So stop trying to equate this stuff. Hey, Kurt, what's up, buddy? One Love Design is also out there. Oh, I love all my mods. So it was knocked down. And so at this point right now, we have to wait 30 days to see what the Ninth Circuit Court of Appeals will do. And both sides are going to propose a settlement within 7 days. FBC and everything is going to say you have to get rid of the law. California might try to walk back the law a little bit, maybe eliminate the semi-automatic rifles. They might do that. I'm not really sure what they're going to do. But what I do know that they're going to do is appeal to the Ninth Circuit Court of Appeals. They're going to ask for a stay. The Ninth Circuit Court of Appeals will probably grant that stay because they have in the past. If you look at what the Ninth Circuit has done over the years when they've been asked by California for a stay, they usually grant those stays. Then it will go to a 3-judge panel. That 3-judge panel, we don't know the makeup of it. Hopefully we'll get a good makeup there, but who knows? After that is done, then whatever the 3-judge panel decides, either losing side can ask for what's called an en banc hearing. An en banc hearing is where the full bench, all 16 members of the Ninth Circuit Court of Appeals, will hear the case and decide it. After that, there's a few different things that can happen. When en banc happens, whatever the 3-judge panel decides is thrown out. It's like a do-over. It's like the 3-judge panel has never happened. If it's an 8-8 tie, it goes down to the district court's decision. Or if there's a majority of judges that decide one way or the other, then that will decide. Then after the Ninth Circuit Court of Appeals decides on what they want to do, it will go to SCOTUS. The losing side will appeal to SCOTUS. They'll file what's called a writ of certiorari, or a petition for a writ of certiorari. A writ of certiorari just means that the Supreme Court will hear the case. So that they will petition the Supreme Court to hear the case. The Supreme Court doesn't have to hear the case. They can, or they can just knock it back down and say, no, we're not going to hear the case. Or they can remand it back down to the Ninth Circuit and say, Ninth Circuit, take another look at this. We're not sure if you got it right or not. So we have to, nothing bad, good stuff happen, or flat. So let's see what happens, and let's see where this goes. But this is definitely a victory for the 2A community. But the fight over this is not over. It's nowhere close to being over. We're still probably a couple of years for this to be over. If you look at like Duncan versus Bonta, which was originally Duncan versus Becerra. In these other cases, they've been in limbo for years, and this case is going to be no different. But it is moving forward, and it is challenging the status quo of gun laws, which is a good thing because a lot of gun laws, especially those in California, are definitely unconstitutional. And I think in the end, they will be ruled unconstitutional. We are winning this battle. If you look at the court cases, the states are getting slapped the F up. And we will, Rich isn't feeling too well today. One car fast. So we will win this. And we'll just have to keep on here. This is a good point. One of the things that they do is they'll just come up with a new law that's basically the same law but worded a little bit differently and have to be sued again and again and again. It happened with DC and concealed carry permits in DC, the right to carry a handgun. Eventually, what happened is SCOTUS got so fed up, they just said, all right, we're knocking down all laws until you bring us a law that satisfies us. And for a few days, you can carry whatever gun, open carry, concealed carry, whatever in DC without a permit. And DC came up with a law like within like 24 hours. It was like insane. And it wasn't like the same law, and they allowed concealed carry permits. It might take something like that to happen. That was Wren versus DC that happened in. So Brian Wren is a friend, and I might have to have him on the channel to talk about that because I can see something happening like that. So yeah, so they might pass a law saying one gun in every 32. But the way that this judgment is written is that you cannot restrict how many times a person actually buys a gun or exercises a right. So I don't think that they will be able to do that, but we'll see what they try to do. I'm not saying that they won't try to do it. I just don't think it's going to fly. Kermit Loves Bacon is right. CT has a 3 handguns a month rule. This could affect that as well. It could affect the Virginia law. It can affect the New York law. It can affect laws across the country. So this is a cool thing forward, and it also gives power to other lawsuits challenging other cases around the country. Because what lawyers can do, let's say if they sue Connecticut, gets sued over the 3 handgun law, right? What the attorneys for the plaintiffs can do is file what's called a order of supplemental authority, which says, hey, look, this district judge in California ruled that this is unconstitutional. You have to take that in consideration when you consider what you do and the judges do. And the supplemental authority does go a long way. They're not bound to exercise that, and the higher it goes, the more they are, but they're not bound to exercise that. But it gives the plaintiff something to argue, saying, hey, look, we have judges that agree with us, and here it is. So it does actually make a difference. So even though that there's nothing today that is changing this moment, and it won't change for at least 30 days, this does give power to other cases and other states challenging Virginia's 1 handgun a month law, unless you have a concealed carry permit, or Connecticut's 3 handgun a month law, or New Jersey 1 every 30-day law. So this actually gives those cases a little bit more firepower. So yeah. And Bill Alexander, they can't do that because the judge basically said that you cannot limit a right. So we'll see what happens here. Kermit Loves Bacon. I think that in the Connecticut law, there's an exception for inheritance and family. So I think when your father passes, I think you're going to be A-okay. Yeah, Rob Bonta will definitely appeal to the ninth. They probably already have that worked out. They probably already have it written up because they didn't know if the judge was going to put it into immediate effect or stay it for a week or whatnot. But now that they have 30 days, they will probably wait all 30 days to file just to increase the time period of the law being in effect. So I would say probably within 20 to 25 days, they'll file for a stay, if not later. And the ninth is probably going to give it to them. Hold on. So this is definitely a victory, though. So don't get me wrong. This is a great order. This is a victory. FPC, Second Amendment Foundation, all those guys did a freaking fantastic job. And this is definitely a win here. Yeah. So we'll have to see what happens here, but this is a good thing. All right, guys, just wanted to make a quick video to let you know what is going on. There's some other stuff going on in the gun world. I'll probably break that news tomorrow. So stay tuned. And with that, we are out of here. Thank you for watching. Stay vigilant, stay free, keeping the fight. I'm going to link the decision one more time down below so you guys can check it out yourself. And I am out of here. Bye.